Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about confessions. Cases that should have gone to the Supreme Court of Canada, but didn't. When a person makes a confession, the confession has to be found to be voluntary. In fact, any statement made by an individual to police must be found to be voluntary in order to be admissible. And voluntariness essentially requires that the person who made the statement have an operating mind at the time they made the statement. That they weren't deprived of an operating mind through threats, promises, inducements, being held without sleep or without access to the bathroom or without food or water for extended periods of time. But in a recent sexual assault case, where the defense related to mistaken belief in age, a statement was sought to be adduced by the Crown on the basis that it was made voluntarily that would undermine that defense. In the voluntariness voir dire, the accused argued that because at the time that he gave his statement to the police, he was suffering from a severe mental health episode, he was denied the operating mind necessary, or he didn't possess the operating mind necessary to make that statement voluntarily. The court disagreed, he was convicted, and the matter ultimately went for a leave application to the Supreme Court of Canada, who dismissed the application. And this case raises very important issues. The voluntariness rule in Canada has been around for a very long time, and it hasn't changed much over that long time. But our understanding as members of society, as members of the legal profession, approaching things from a trauma informed perspective, and knowing more about the extent to which mental health can impact people has changed significantly from when the voluntariness rule was established. It would be important now that we have this deeper understanding of how mental health can affect people's cognitive abilities and can affect people's decision making to have the voluntariness rule revisited in the context of mental health conditions. Certainly, there are going to be cases where it's obvious that somebody's mental health is so bad that they aren't capable of giving a voluntary statement. But what is the line? What is the test for when somebody's mental health does rise to the level of being so bad that it renders their statement involuntary, or that it allows the police to take unjust advantage of their bad mental health in obtaining a confession against individuals? The Supreme Court of Canada missed the opportunity here to create a very clear line and to develop the law on the voluntariness rule far more than it has been developed in the last 30 years. It was an unfortunate opportunity that was missed by the Supreme Court of Canada to really drill down on this issue that has gone unanswered and that ultimately risks confessions being included in evidence where they were obtained not as a result of somebody having an operating mind, but as a result of somebody having cognitive difficulties or decision making difficulties as a result of their mental health. Hopefully, there's another case that allows the Supreme Court of Canada to revisit this voluntariness issue where it pertains to mental health episodes and develop a good, clear test for judges to follow in determining whether statements obtained in those circumstances are admissible. Cases that should have gone to the Supreme Court of Canada but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.